Okay, let's see. I think we left off in the small claims, which is what we're going through here. Left off somewhere with service, if I'm not mistaken. Does anybody remember? We leave off with service? Oh, you're all asleep. Okay. Well, I was here, and I think it was service, chapter 11. So we got into, we did get into, filing the paper and all that stuff. I guess I was the only one here. Okay. Okay. Well, I'll start with with that. Yeah. Okay. It's the same book we were doing with the last tape. By the way, I need two tapes. The one before this and this. Small claims. This is for everywhere around the country. Okay, all the states. By Nolo Press, and it's called Everybody's Guide to Small Claims. But what we're dealing with is the small claims. When you fill out the, I'll go back one chapter before service. We'll go to filling out your paperwork and getting your court date. Okay, small claims court clerks are required by law in most states to give you as much help as possible. Okay, short of practicing the law. The problem is they think answering a question is practicing the law. So sometimes you have to help them out. That it's not practicing the law by answering a question. That's what they're there for. But they are there to provide you some help, and some of them really do. One of the most important things is when you fill out your complaint for small claims, you don't need to put any evidence with it. Okay? The evidence is done, because this is pretty informal, small claims. The evidence and everything else is done in the courtroom when you appear. And I'm talking about the plaintiffs. The defendant doesn't even have to answer, at least in California. You just show up. But when you write your complaint, you just put down what it is. Very simple, very straightforward, and you don't have to elaborate extensively. You just tell him basically what it is, because he's going to find out what it really is when you get there. Okay? So you don't need to provide any evidence with your complaint. You just tell him what it is. So then when you bring in your papers to file with the clerk, you're going to then ask for a date for the small claims. And she'll have a variety of dates. Pick one that's convenient for you. You're also going to have to make sure the other party receives service in between the time you file your complaint and when you show up, because you're going to have to file proof of service, the fact that they got the summons and this complaint. You're going to have to give a copy of that proof of service to the court clerk so that the judge will know that, yeah, the other party did know they were supposed to be here. That'd be nice. You didn't have to tell them. Then you get a default judgment every time. But anyway, you arrange for a court date that's convenient for you. And like I say, you do need to make sure you have enough time to get the service done and get the answer back that they were served, especially if you do it by mail, which you can do in some places. Okay, now, the defendant normally doesn't have to answer. They just have to show up. In small claims, especially in California, there is no jury. Okay, so if you go to small claims, ask for a jury, forget it. It don't exist. Small claims is just you, the other person, and the judge. Hopefully he's a judge, not a judge pro tem. But that's it. That's all there is. And you can basically, the only time, if you're the plaintiff and you're suing for an amount, the most you can sue for is about $5,000. I think it's twice. And you can sue for, after that, $2,500. There's the maximum amount you can ask for in small claims. The only way it can get past that is if you're not the plaintiff. If you're the defendant, somebody sues you, and you countersue them. In other words, let's say the most convenient, or the one that works best for me anyway, is let's say there's an accident, right? Two cars bump, yours and somebody else's, and the other person sues you. saying, hey, you know, you jumped the red light, or you jumped the light and pulled into the intersection, caused them to get in an accident, all this, you know, blah, blah, blah. And of course, what you know that happened is the light had changed green for you. You had gone out to the intersection after it had changed green, and they tried to shoot through. So you're suing them. But they're making a claim for $5,000, and you're making a claim for $6,000. Well, $6,000 doesn't work in small claims because the maximum is $5,000. And what they'll do usually is one of two things. They'll either say, okay, you go up to municipal where the rules are more formal, or you accept the $5,000 limit on your claim. Sometimes they may even say, well, we'll go ahead and allow the $6,000 on your claim. We'll just hear it in small claims. Okay? So that doesn't happen too often. Usually they tell you, look, either you hear it here and you accept $5,000, or you go up to municipal court and you go through all the rigmarole that goes on there, the more formal setting. So you get to choose which one you want to do. Now, if somebody doesn't show up, if you're the plaintiff and the other person doesn't show up, you get a default judgment. Okay, usually when there's a judgment rendered in small claims, they will send it to you. And the reason they'll send it to you is because they don't want to have the bailiff to wrestle down the guy who loses because he's all upset. Okay? And the best way they feel they can avoid that problem is not to tell you who won. Send you home and send it to you by mail. Then your wife can wrestle you down when you found out you got upset. And that way they don't have to do it in the courtroom. So that's how they usually notify you. But when the other party doesn't show up, then it's a default judgment. And a default judgment means that, as far as they're concerned, you won. But in California, there's a waiting period of about, let's see, the person, usually they have about 30 days. If they haven't shown up on the day of the trial, they show up within 30 days saying, hey, I didn't show up for some good reason. Then what they'll do is they'll set aside the judgment, have a new court date, and then you'll get to argue it. Okay, as long as it's a good reason. Also, if you win a judgment, they have 30 days to file an appeal. As a plaintiff, if you lose, you're out. That's it. No appeal in California. The only person who can appeal in California is the defendant. Now, if somebody countersues you and you lose, then you are the defendant in that case and you can appeal. But if you're the plaintiff and nobody's countersuing you, in other words, the defendant's not countersuing you, if you lose, you lose. No appeal, no going up after that. Okay. Also, if there's usually a default judgment, the judge will usually tell you right there. They'll say, default is entered. And so you don't have to get a mailing telling you won the default. Now let's see. I told about the appeals. If you want to, now let's say that you are the defendant, and for some reason you miss the court, and there was a very good reason why you missed it. Then you need to try to set aside the judgment. The reason how you set aside the judgment is you file a writ, which is called a notice of, or actually this case a motion, but it's you put in a motion, a notice of motion to vacate judgment, and if they execute the writ of execution has been served on effort to collect. You must file a motion so that the writ of execution is suspended. The writ of execution is there's a default against you, and they go out and they get immediately, let's say, they don't wait the 30 days, and they get a writ of execution saying, okay, now we can go after your bank accounts, your wages, and all this other stuff, and you then file a motion to vacate the judgment because you had a good reason for not being there, like the service was bad. They didn't serve you personally, they served somebody else in the household who then said, yeah, I'd take it for them. Okay? Not proper service. So what happens is you then have a good reason why you didn't, you weren't there because you didn't know. So they set aside if they vacate the judgment, then you get a writ to, that vacates or stops the writ of execution to go after your money, which of course you don't want them to do. And that is often called a motion to stay or quash the writ of execution. And by the way, almost everything I'm telling you about here, there's a form for it. Okay? There's a form to vacate a judgment. There's a form for a writ of execution. There's a form for a motion to vacate, you know, and a motion, and also to quash the writ. They've got forms for everything. All you have to do is, if you know how to write your name, you can practice law. Okay? Because all you have to do is write name and put an X in a box most of the time. And everything else is on the form. A little description, and there you go. Now, vacating the judgment, vacating a judgment of dismissal. So the judge can and do vacate dismissals if both the circumstances exist. If the plaintiff moves to have the judgment vacated immediately upon learning of his mistake, let's say that the judge made a ruling, a judgment, and it was against you, and you found out that you had made a mistake somewhere, a mistake of law or something like that, and you come back to the judge and say, hey, you know, I know you decided against me, but I want to put in this motion because I made this mistake and it was crucial and critical to the decision that you made against me. And he could then vacate his judgment based upon that mistake. Doesn't happen very often, but he could do it. Or if you have a good explanation why you're unable to be present. Okay, so if you weren't there as the plaintiff, if you weren't there for some reason, and you have a real good explanation, like you're on your way there and somebody T-boned your car and you're in hospital for 3 days, you know, that's a good explanation. That's probably why you weren't there, because you couldn't make it. So if you have good things like that, if you as a plaintiff aren't there, he will vacate the judgment against you for not showing up, if you, again, have good reason for not being there. Okay, now, we'll get into service. Assuming that, I think we already covered in the other tape, we covered on how to present or how to determine if you have all the elements for the action that you want. For instance, if you have a contract, what are the elements? Now, the best way to find this out, as I told before, is to go to the law library, go to AmJur, look up contracts that tells you those things. Look up in the pleading and practice forms of AmJur as well. Those are a separate set of books, and it will tell you what elements you need to prove. Now, in small claims, they're not really requiring you to prove it per se, but the judge is looking for those things in your case. So if you come and you say, okay, judge, you know, this person violated the contract. He agreed to pay me X number of dollars, and here's a payment of a check to me, and there's no other checks being paid to me, and here's a copy of the check, and you have everything there, except you don't provide the contract. And then he says, well, I never agreed to pay him anything other than this $500 that I paid him. Well, now the judge is going to decide against you because there's nothing to establish that anything other than the $500 was owed, because that's all that was paid. Okay? So one of the elements that you would want to prove in that kind of case, which is the contract, you need to make sure you have it there. So the judge is going to ask you these things, but it's important that you know what you need to prove before you get there. Because if you don't have the evidence and can't provide it, you're probably not going to win your case. And he who is most organized with the most information and evidence wins. It's like, you know, he with the most toy wins. You know, he who dies with the most toy wins. You know, really, he who dies with the most toys is dead. You know, but on the back of the cars, for some reason, people think if you die with a lot of toys, you're a winner. I think you're dead. But in a case like this, he who has the most evidence to prove his case wins. And that's what the judge is going to be looking for. Okay? So all defendants, okay, who must be served? Well, first of all, everybody that you list on your case must be served. And this applies not only to small claims, it also applies to municipal or superior or wherever you go. This service is the same. Okay? So with anybody you list on a complaint, they've got to be served. You've got to proof of service that they received a copy so that they were notified that they were being sued, and they better show up because this is the date that this thing is going to be heard. And this is true even if you're suing a husband and wife. Each one must be served. Okay? You can't serve one and say, well, I served one, the other one will tell the other one, you know, if they communicate.
And name them both on the same.
Yeah, if they're both named, they both have to be served. If you got John Andrew and Mary Andrew, then you better have service for John and you better have service for Mary, even though they live in the same place.
What if you name two people and the corporation they represent?
Well, you better show service of the two people and the corporation.
Then who do you serve with the corporation then? Who you have to determine?
I haven't got there, but we'll get there.
Oh, okay, you're going to get up to that.
Okay. Yeah. Okay. We'll deal with that everybody must be served. I'll tell you how to serve different types of individuals in a little bit. But right now we're just dealing with who must be served, and who is anybody that you've named on your complaint. Okay? So, and now where can you serve them? Generally, especially with small claims, it's anywhere within the state. Some places it's anywhere within the county. Okay, but that's not California. So it's anywhere within the state in which your action is brought. And I think we talked about where your action can be brought before, which has to be either where the contract is signed, where the incident occurred, or where the defendant lives. Okay, those are the places. Okay, so, no, they're all equally valid. You can pick in that particular case. Okay, so, now, if they don't do business in your state, you're out of luck, okay? If they're out of the state, other than like an automobile accident, but outside of that, if they're out of the state, you're outside the jurisdiction of your state. Your state can't reach into the next state and grab somebody, at least not civilly. They can do it criminally through agreements between the states, but they can't do it civilly. So you can't reach to another state. You got to either wait for them to come into the state so you can serve them, or you have to hope that they do business in here some way so you can do it that way. Now, how do you serve your papers? This is the fun stuff. If you can't find the defendant, don't file the lawsuit, okay? You're wasting your money. Your $60 that you pay to have the thing filed, or $40, I think, in California. But if you file so many, it costs more. I think 60 if you file over 13 in a year. But if you can't find the person, don't bother starting a lawsuit. I'm sure you can get a judgment if you can serve them. But if you can't serve them, you can't even get a judgment because the person has to be notified something's going on. Okay, how do you serve them? Personal service. Here's a couple of different ways you can do it. There's about 5, but there's a sheriff, marshal, or constable, depending upon the state you're in. We have sheriffs, okay, and marshals. They've been kind of merged into one entity nowadays over here in California, but all states allow personal service to be made by all officers, so you can have them do it. You can pay them to do it. And if you win, you'll get your money back in the judgment. At least it can be added on to the judgment, okay? I don't remember what it costs, somewhere between $20 and $30. Now, you can also pay a private process server to serve the papers, which is the same thing. In California especially, you can use anybody. You can use a disinterested third adult. In other words, your friend. If you have a good friend, you can have them serve the person. As long as it's not a party to the action. They got to be 18 years or older, obviously. And you can even use a friend or a relative. Doesn't really matter. Let's see. Now, if you use this method, it must be handed to the defendant. Remember I said personal service. You can't leave it at their home, in their mailbox, or anything else. You have to give it to them personally. It has to be given to the right person if it's an individual. However, let's say that you find the right person, okay? you come up to the person and you say, you know, are you John Adams? And they say, well, yeah, I am. Says, well, I got some papers for you, you know, some court papers, etc. And they say, well, I'm not taking those. What you do is this. You say, I got some court papers, and they say, well, I'm not taking those. So you drop them, say, you've been served, and you walk away. And you let them sit, because that's service. As long as they had notice, okay? When you said, I have court papers, this is service, and they said, well, I'm not taking those, that's too late. They have been served. They just drop the paper, say, you're served, and you say, bye-bye, and that's it. They have been served. You don't have to fight with them. You don't have to stuff it in their pocket or put it in their car window or anything. You just drop it, okay? That's all you need to do. Let the wind take it from there. Okay, now another way you can do it is certified or registered mail. Now the nice thing about California, which you'll read in the statutes if you read the statutes on service in California, is that if you use the lesser expensive way, instead of using a process server, you use registered or certified mail, which you also have to include, by the way, a paper for them to respond that they got it, in addition to the receipt showing they got it. But if you use that and they don't respond, and therefore now you have to do personal service because you didn't get the response saying they received it, in California, they let you then add the cost of doing that extra service and the certified mail as a cost, and you get that even if you lose the case. So, but you have to ask for it. But you still get it because they're trying to lessen the cost, and if the person refuses to cooperate, then the court says, well, fine, you're going to pay, you know, for them having to use the more expensive route. And so you'll get that even if you lose the case. You just have to ask the judge, well, judge, you know, I did this. And they had sent it by certified mail, and they didn't answer, and so I had to do personal service, and my costs were these. And so you'll be awarded that. So that's a good thing to do. Okay. Now also, usually, if you do it by certified or registered mail, it will be sent out by the court clerk. They charge a small fee, but they'll send it out. Then you need to check with them to make sure that they got something back. And if they didn't get something back, then you need to do the personal service. Okay, you don't want to show up to a court and just assume that something happened. Okay, regular first-class mail you can't use. Not in California anyway. There's some states you can, but not in California.
What if it's a post office box?
Hmm?
What if it's a post office box, private or public?
Oh, it don't matter as long as they sign for it.
So an agent at that if they have the authority to sign for something.
Well, most post office boxes, they do have the authority to sign for it. Okay? In fact, you'll find that most post office boxes don't want to get involved in this, so you signed a waiver that they will sign for everything, whether you want them to or not. That's why I say go general delivery. Because general delivery, well, you can't have certified and registered mail sent to general delivery. And so it means they got to do personal service on you. So, anyway, just something to keep in mind. Okay. Now, in some places, they allow you just to notice them by what they call nail and mail, okay? Or which is to nail a notice on their door of their house and mail a copy to them, and it's presumed they got it, okay? However, I don't think California, they want you to do that. But there are states that allow you to. So, you know, check with if you're outside of California, check with your place and find out if you can nail and mail and run. Okay. So, that's really a funny one, but that's what they do. Okay. Now, the other method is by serving the subpoena only. Subpoenas can't be served by mail. They must be done by personal service. A subpoena is when you have somebody that you want to have testify for you, okay? And you're not too sure whether they're going to show up or not. And so you subpoena them. However, I would never subpoena anybody who didn't know you were going to subpoena them, because then they might be a hostile witness. And you don't want a hostile witness. It's bad enough as it is. So you should always, if they're working, let's say, and they know they can't get the time off, but they'd like to come in and witness for you, then you would want to subpoena them. So their job can't prevent them from going. Okay, the job has to allow them to go now, because otherwise they'd be violating a court order and they could be held in contempt of court. So, you know, for reasons like that, you'd want to subpoena somebody. Now you can also use another type of subpoena, which is called a subpoena duces tecum, which is a subpoena for documents. And that you'd be subpoenaing the other side for them to bring forward information. And that usually is not brought to you, it's brought to the court with them. They give it to the judge, you get to look at it, but you don't get a lot of chance to review it. And if you need more chance to review it, then you have to ask the judge, hey judge, I need some time to go over this thing, in which case the judge may either postpone the hearing or may allow other people to go in front of you while you examine the documents. Okay? So those are two different types of subpoenas. A subpoena for a person, or subpoena duces tecum for things, documents and stuff like that. Okay, now, the time limits that you have to put people on notice varies from place to place. Generally, you want to give them as much time as possible. Okay? So in other words, when you file your complaint, you want to immediately have the service done so that they have as much time as possible, because you may not actually get the service done when you start it. It may take a while. Like if you do it by mail and it comes back and says, whoops, you know, they're not responding. Now we need personal service. Now we got to arrange and have that done, and then they've got to find the person, you know, catch them at their door or whatever, or the workplace or some other place like that. So you make sure that you give yourself enough time between when you file a complaint and when it's going to be heard, that you can make sure service is going to be done. Because anybody who's not served, they are out. Okay? They are out of the judgment. There won't be no judgment entered it for them, and they won't be expected to be there. Now, okay, let's see. Okay, now let's get with types of service. Okay, if you're serving a business, for instance, a sole proprietor or a partner, you've got to serve the person individually. Okay, so if you got ABC Plumbing, and it's not ABC Plumbing Inc., it's just ABC Plumbing Company, so we either have a sole proprietorship or a partnership, then you have to serve the individual of that company. Okay. However, if you're suing a corporation or a limited liability company, even though the corporation and the limited liability company is a person for purposes of the lawsuit, you still have to serve the paper on somebody who lives and breathes. Okay? So even though a corporation is considered a separate legal person, you have to give the paper to somebody who can do something with it, you know, who can live and breathe. For that purpose, the Secretary of State has names of officers or people who have been classified or designated when they did their corporate charter, etc., as the person to receive legal service. And all you have to do is talk to the Secretary of State or the Department of Corporations, and they'll tell you. Now, one of the easiest things to do, for instance, like when you go to a bank, for instance, the bank has one president, but they have tons of vice presidents. Okay? Vice presidents everywhere. It seems to be a status thing. But one of the nice things about all the vice presidents is that they can receive service for the bank. So you just find a vice president somewhere, and you give them service. Okay? And now that bank's been served. Because it's president, vice president, secretary, treasury. Okay? Those are the ones you have to serve that corporation. Or the person who is designated as the individual to receive service for that corporation. Okay? Any one of those will do. But that's how you serve a corporation. Now, if they won't tell you who these people are, like I say, you can find out who the person is supposed to receive it from talking to the licensing board of the Department of Corporations or somebody like that. Now, let's see. You can also just leave summons and plaintiff statements, or complaints that is, at the defendant's place of business if it's a corporation. If you're serving a public agency, the real problem with public agencies is even though they give you 4 years on a contract issue, they give you on a public agency 6 months to know you've been injured and file a complaint. But against each other, they give us 4 years to fight with each other, but to fight with them, 6 months. Okay? Obviously, they know they have something to hide. So they've limited the statute of limitations as when you can file a complaint. However, before you can file a complaint with the city, you have to first exhaust your administrative remedies with that city, which means that you have to file a complaint with the city and a request for payment. You know, in other words, an officer dragged you out of the car and beat you, okay? And so you say, hey, this isn't right. And so you want to sue them. Well, you first file a complaint with the chief of police at the police department saying, hey, he owes me X number of dollars because my medical bills with this, he did this wrong, etc. I want to know what you're going to do with the officer. Please pay me X number of dollars, which they give to the city attorney, and the city attorney takes it and recommends to the council board what they should do, which is always don't pay them. Okay, so after you get your no, we're not going to pay you statement, then then you can file your complaint with them. Okay, but that's how it works.
That when the 6 months time starts?
No, actually, the 6 months time starts from the date of the injury.
So they can mess you up just in there.
Well, if they haven't replied, you can start your lawsuit anyway, because if they're purposely dragging their heels, try to get past the 6 months limitation, you can file your lawsuit pending the response. So you can file a lawsuit and just put in there that they haven't responded, and therefore you deem it's a denial. And yeah, if they don't deny you, great, be one of the few. You know, but more than likely they did deny you, and they're just trying to see by not answering if they can get you past the 6 month statute of limitation. Okay. Now, after you make the service, you got to let the court know that these people have been served. So whoever did the service for you, since you can't do it yourself, they have to fill out, usually on the back of some of these forms, they have a proof of service, and they fill it out, saying that this person was served at this time, at this place, by you, whoever the you is that did the service. And then you take that and you enter it into the record in the court. Now the court knows that there was service done, so they've been notified. So they've been notified, now they can proceed. At least if they don't show up, you can get a default judgment on them. Okay. Now in California, if you are the defendant and you have been served with notice and you want to file a counterclaim, you have to do that 5 days prior to the date of your court hearing. Okay? In other words, you've got to have service on this person 5 days before the date of the hearing. Now let's say that the plaintiff has disappeared because he didn't want to be counterclaimed, right? So he goes away and he's off on vacationing in Tahoe or something, and he's coming back the day before the trial. So he comes, so you're not able to do service on the guy. Well, what you do in that case is you then bring your counterclaim, basically your cross complaint, with you to the court, outside the hallway, not inside the courtroom, but outside the hallway. You see the guy, you serve it on him at that point, and you do it personally, and you can have somebody else do it, but you can do it personally at that point. You go into the courtroom and you tell the judge what happened, that you tried to serve the guy who wasn't around. So it's the first chance you've had to serve him, you've served him, and you have a cross complaint. And so now at that point, the judge can decide to either, well, he'll probably ask the plaintiff, well, do you need time, you know, to work a defense for this, or do you want to proceed? And they'll probably need time, and they'll postpone the date to a later date so he can make some kind of defense. Okay, now, if you're trying to serve somebody in the military, good luck. You probably won't get it. Congress has given them all kinds of exemptions and special privileges and things like that. So if you got somebody in the military, don't get any contracts with them till they're out. Now, you can, if they are out and they're making a claim they're in the military, you can file a statement with a court, an affidavit saying that these people aren't in the military. And the court will actually usually rely on that. But I wouldn't say it if it wasn't true. You could get in a little trouble. Okay. Now, let's say now that, well, let's look for some, if you're the defendant, okay? So if you're the plaintiff, we know we've done all the service. Now, what if you're the defendant and you've received this stuff? What kind of defenses can you make? Okay, as the defendant, you can make a defense of, I didn't get service, okay? There wasn't proper service. All that does is buy you some time, because after all, the judge can say, well, you're here now. I wouldn't not show up if you didn't get proper service, and the court date is either present or in the near future or whatever. Because if you didn't get it and you don't show up, the judge doesn't know you didn't get it, and he's going to enter a default judgment. Now you got to go through all the extra work to get the default judgment set aside, and maybe a writ of execution set aside, so that the trial can be heard. So, worst case, if you don't get proper service and you do find there is an action against you, you should show up and tell the judge, hey, I never got service. And then they'll say, okay, now you know, we'll move this thing into a couple of, a week or 2 weeks or 3 weeks into the future, and then you come back and you have it. Now, how about if you are, as the defendant, you're partially wrong? Well, if you're partially wrong, try to compromise. Try to work out with the other person some kind of compromise on it. Because there's no guarantees when it comes to small claims. So I would try to work out a compromise. Now, if you're judgment proof, which means you have nothing, well, you can rely on that too. But the problem is with small claims or any kind of judgment, in California it's 10 years. They hold it against you for 10 years, and if they still remember after 10 years they have a judgment against you, they can renew it for another 10. So you got 20 years where you can have a judgment sitting on you. So, and they can affect your credit and stuff like that if you use that kind of stuff. And you may not like that. So it's definitely to your advantage, if you know or think you might lose the case, to try to compromise. Now you can always try to mediate. Get somebody in there to mediate for you and say, listen, let's go to a mediator, have them decide what's fair, and we can then, I'll pay you based upon what they decide. Or we can hear what they decide and see if it's fair. And you can do it that way. Now, if you're going to court, and whether you are defending or whether you are the plaintiff, these are things you need to do in order to win. First of all, analyze, if you're the defendant, and maybe I put it this way, if you're the defendant, let's do the defendant first. If you're the defendant, analyze what they've got to legally show to prove their case. Because the plaintiff has to show maybe 5 points, and he has to prove every one are true for there to be a judgment rendered against you. So that means as a defendant, all you have to do is show one of those points are not true. You show one is not true, that's it, okay? Assuming you're getting a fair trial. It's always a big assumption. But assuming you're getting a fair trial, you show one is not true and you're out. Okay, and the next is to develop your evidence. You want to show, if you know what the person has filed a complaint, so you kind of know what they're doing. If you've tried to work with them at all, in other words, you file a complaint, you call them, say, hey, you know what's going on here, how can we work this out, this kind of stuff. You'll have an idea of what they're trying to prosecute you on and what their reasons are. If you have that, then you'll know what kind of defense you need to make. And so prepare your evidence. Just having a conversation, like most people, if you go to, you watch those small claims actions, they got Judge Wapner now, Wapner with animals or something. He's doing animal cases. And they got this other black gentleman doing what Wapner used to do, and actually I think he's very good. And they got Judge Wacko Judy, and she's I shouldn't say this, but she seems to me like she's on the edge of PMS every day. But anyway, that is not real in most small claims court. Okay. What's happened to the small claims court is very, very straightforward. It's parading people through. So what the judge wants to hear is he wants to hear a concise presentation and the evidence that supports it, and that's it. He doesn't want a history of your parents or what you had for breakfast or anything else like that, which a lot of people like to talk about.
Do you have as much time to present your claim as is necessary?
Sure, you have as much time as you want, but the judge will be asleep after 5 minutes. So don't use more than 5 minutes to present your claim. And the small claims, you shouldn't really need, unless there's some real complicated technical legal issues, you shouldn't need more than 5 minutes. I can within 1 minute present a contract case, everything I need to show. I can say, well, we had a contract. Here's the contract, Your Honor. Hand it to the bailiff or the clerk who would give it to the judge. And you say that he's paid me these much dollars. Here's the payments, Your Honor. He hasn't made any other payments at this point, and he's in default. He owes me this much money. There you go. Less than a minute. Okay, I presented it. I gave him the evidence, the contract. I showed him the payments that have been made so far. And that's it, Your Honor. Well, I've proved my case. Now they have to prove that, no, Your Honor, I paid some additional payments, or, well, there's not much else he can argue, unless he knows how to argue signature. But that's another issue altogether. Won't talk about that here, so they're arguing both sides. But now if you have eyewitnesses and stuff like that, basically you're going to want to bring them forward. And you have two types of eyewitnesses, or you have two types of witnesses. You have eyewitnesses and expert witnesses. An eyewitness is somebody who saw it happen. An expert witness is somebody who's an expert in the field, and therefore you bring their testimony up because it's relevant, like a car repair, okay? Somebody repaired your car, did a lousy job, you took it to this other person who's been in the business for a long time, you looked at it and said, yeah, this thing is all messed up. Okay, now you can bring that person as an expert witness because he says, yeah, the car was all mixed up, And so you have an expert witness showing that it should have been done this and they did that, and et cetera. And so now the judge knows that there was definitely something that happened that should have been taken care of that wasn't. Now, the other thing you need to do is practice your court presentation. I don't know if any of you are in plays when you're in school, but what they did mostly is practice. Practice, 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 practice. And that's what you should do. You should practice so you can lay this thing out and have it flow smoothly. Of course, once you get to court, you start laying this thing out and it's flowing smoothly, and then the judge interrupts you because he has a question. So your concentration is going to be interrupted. And so when you practice, you should have somebody there acting like a judge who's interrupting you. Well, I have a question about this. Well, what about this? Something over here. Who's going to try to get your thoughts to stray so you don't make your presentation. Okay? Because that'll happen. Not that he's trying to get you to do that, but he has a question about in your presentation that he doesn't understand, so he wants to query you on it. And he'll do the same thing on the defense. Okay?
Is it true if you state for the record they cannot interrupt you?
Well, yeah, but the problem is you're in small claims and there is no record. So if you state for the record, the judge will say, what record? Says, you got a recorder? We don't got no records. We don't need no stinking records around here, man.
But if
Because
it's
they're-
appealed,
What
it
does the defendant
becomes
do?
by court record, does it not?
What's that?
If it's appealed by the, let's say you
That's why
prevail.
if you appeal something as a defendant, let's say you lose and you appeal it, it's trial de novo, trial from the beginning, because there's no record. Therefore, there's nothing for them to go on. All they have is an order. This
But-
guy won.
When it's appealed, it
Okay.
becomes a
Well, on the appeal side,
record, right?
yeah, it can be a court of record.
Right, okay.
Whether it is or not,
Well,
Good
can you
question.
insist that it be?
well, yeah, you can always ask. Okay. Okay, so now, again, if you're the defendant and you feel that that is the plaintiff, did something wrong to you, you can always file a counterclaim. Okay. Now, here's what you need to do when you go to court. First of all, you need to get Judge Judy and Judge Wapner and all those people out of your mind, because that's non-reality there. And of course in California you have free legal advisors with small claims, so you can go up there and ask them some questions and stuff and things you're confused about, and they'll tell you, for the most part, what's going on. But you can't ask them how to prepare your case, because they won't do that, because that's be practicing law. Okay, whatever that means. That must mean they really haven't got it down yet, and they got to keep practicing until they get it right. But they claim it's practicing law if they tell you how to do these things. So you're going to have to figure out how to present your case for yourself, but that's what we're going through here. In California, you cannot have a lawyer. There are some states like Massachusetts which allow you to have a lawyer. Of course, I don't know why, because by the time you finish paying the lawyer, you've paid out more than what you're going to get. But you are allowed there to have a lawyer, but you're not allowed here to have a lawyer. You cannot have a lawyer in California in small claims unless the lawyer is the defendant, or I think he can be a plaintiff too, but usually that's not the case. Okay. However, you can, if you want, hire a lawyer for some advice. If you're confused about some legal issue, whether you get a strong case, you can always hire him and ask him something, and he can tell you whether it's true or not. You can go for mediation or arbitration. Now, the two are not the same. Mediation is where they have some third party who mediates between the two of you while you two talk and tries to guide this towards some settlement. Okay, it's not binding. Arbitration is where you have a lawyer who steps in and tries to arbitrate and makes a decision as to who's right or wrong. And arbitrations are very bad because usually the lawyer is not practiced in the area of small claims and what usually occurs in small claims. And so they don't really have any idea what's right or wrong. So, but they try to mediate because after all they're practicing law with a license, and therefore they do the best they can, but unfortunately they make a lot of mistakes. Now, when you go to the small claims courthouse, recognize that normally it is not in the regular courthouse. It's usually set off somewhere else, like here in Torrance. It was in the bungalow back there behind the courthouse. A little trailer raised off its foundations that somewhat floated on who knows what out there. And you'd go in there, and that's where they had small claims. And then you went across the sidewalk into the building, into the smaller building, to actually have the case heard. But I think they're doing some work. I don't know if it's been finished, but while they're doing the work, it was meeting down here, down there, in Redondo Beach, at the courthouse there. But you can ask the small claims clerk, well, as you know where it's at as a plaintiff, but as a defendant, you can find out and find a small claims clerk, and then she'll tell you where it's at. And in small claims, no record is kept. So when you appeal, they start the game over from the beginning. The process they're going to have is use the plaintiff. They're going to call you all up, and they're going to say, Smith versus Jones, and then you're all going to call up. There'll be a big table in front, something like what's here, and the plaintiff with all their witnesses will sit on one side, usually looking at the judge. That's on the left-hand side, and the defendant with all their witnesses will sit on the right-hand side, looking at the judge. Normally, sometimes not the case, but normally that's the way it works. And then they'll ask the plaintiffs to stand up and state their case. Okay, and then after the plaintiff is finished, he gets to state his case, put his evidence in, bring forward his witnesses, and no matter what happens, if you're the defendant, no matter what happens, don't stand up and say, liar, liar, not good, because you'll get your chance to say something, okay? And the judge don't like it anyway. So even though they may be lying, and it may be very bad, it may be complete fabrication that really upsets you, don't say anything. Wait for your turn, because it'll be a strike against you if you do. You can't maintain yourself. That's what the bailiff's there to help you maintain if you can't. So after they present their case, and then the defendant stands up, which if that's you, you get to stand up. If you're the plaintiff, you've already done your thing, and you present yours. And now if they fabricated somewhere, you can say that, but you don't say it right at the beginning. You say, oh, I believe, I'll prove that what he said is in error, or he made a mistake, or it is not true what he said. And then you bring forward your evidence and your witnesses to prove your case. Okay? So, anybody here see that movie Princess Bride? Remember the guy that brought the prince, I guess it was, or the pirate back to life? Does anybody remember that? Oh, those of you who didn't see, you don't have a clue what I'm talking about. But it's a little guy with that high squeaky voice, and it was really funny. He's a little Jewish guy, but his wife come in, and because he was saying, well, I can't do this. I've been fired by the king. I've been depressed ever since, and all this stuff. And the wife, and it says, oh, I can't help you. He's too far gone. And he put something in his mouth and put some air in it and pushed it to hear what he had to say, and he said something. I can't remember what it was, but the other guy says, no, it says he had too much drinking and stuff like that. He can't be helped. And the wife says, liar, liar, liar. The guy was pointing his finger at him. Reminds me of the movie you see where the wife is chasing the husband around, pointing his finger at him. But that's what reminds me of when I see Judge Wapner and Judy. I see those people pointing their finger at the other person. That isn't what happened. No, this isn't what happened. No, that's what happened. Well, just the one story against the other. Anyway, sidebar gone. Now we'll get to the point. When you deal with the opponent, always be polite, and like I say, don't argue what they're talking about. Also, whatever they present, like if you're the defendant, when they present stuff, if you agree with what they presented, like you agree there was an accident, you agree the two cars hit, okay? Don't rehash that. Judge doesn't want to hear it if you agree with it, okay? You want to talk about the points you don't agree with, and you just bring that forward in your presentation. As a plaintiff, you want to start with the presentation of what this case is about. For instance, you don't start with when he says, okay, Jones or Mrs. Jones or Mr. Jones, present your case. You don't say, well, it all started when I was eating breakfast this morning, and I was having oatmeals and with raisins and had some milk, and then I got in my car and I head down the road and I saw this really nice flower shop over there, which I stopped and shopped at, and then I proceeded down the road and I got to this intersection, and he don't want to hear that, okay? He's got a lot of cases. He don't want to hear it. What he wants to hear is, Your Honor, this is a case where there was an accident between two cars. The defendant's cars, I was in the intersection, the plaintiff's car pulled out and hit my car while I was in the intersection, causing $865 worth of damage. And I believe the defendant came in the intersection before the light changed for him to proceed, and the intersection wasn't clear anyway for me to leave. And thus he ran into me without cause, without justification. And then you start presenting your evidence, okay, and your eyewitnesses at that point. So that's the way the judge wants to hear it. He wants to hear concise, presentation. He doesn't want to hear what you had for breakfast. Okay? Now, in dealing with the judge, you may find that you don't like the judge, or you may have gone to the court and found out you got this judge and you don't like the way he rules, he or she rules. Okay? You may feel that this person just, you know, let's see. Well, let's pick something real easy. You're a male, she's a female, and she always rules for the female. Okay? Or the other way around, you know. But you are the ones that she doesn't rule for, or you find her cases are very arbitrary and they have nothing to do with what's presented. In a case like that, you would then say, I feel that when you get to the courthouse, you would say that, and stand before the judge and say, well, Judge, I'd like to dismiss you because I feel that in this case that you would be prejudiced against me, and I'd like to request a different judge. Generally, with the first judge, they'll let you do it, and they don't have a problem, at least in California. They might have a problem with some other states. They might have to actually put it in writing, but in California, you just have to state it. You know, this is what you feel, and therefore you want to change that. Now, don't forget to organize your information. Put it in paragraph form, what you're going to talk about, and then label the evidence that you're going to present. Have your evidence stacked from the first one you're going to give them to the next one, from the top down. So as you, like in the car accident thing, you would have probably the first thing you want to talk about is the damage. You know, he did this, and the damage was this amount, and here's the damage amount, Your Honor. Or maybe you want to talk about the witness, that somebody saw this thing happen. You know, the person proceeded out here and had an accident, and my witness, Mrs. White, saw the whole thing, and I'd like to have her testify. You know, then she'd stand up and testify as to what she saw. By the way, when you have a witness, it's okay to rehearse it with them. It's not against the law to practice what they're going to say. Okay? So some people think, probably from watching Perry Mason, that you can't discuss the case with them or review what they're going to say or things like this. Small claims court is pretty informal. You can't coach them and say, well, you got to say this. Yeah, I know you saw the white car go through before the blue car, but I want you to say the blue car went through before the white car. Okay, you can't do that. But you can ask them to review what they would say to the judge and to take notes and to practice what they would say. And that's okay. There's nothing wrong with that. And you definitely want to do that because you want to know how they're going to sound and what they're going to say, and to make sure they're not going to say something inadvertently that's harmful to you. Because there have been sometimes witnesses has inadvertently got confused and actually testified for the other side, which is not a good thing. But basically, if you have a witness, they should be believable. Okay? Somebody that looks like a drug addict you've dragged off the street, you know, you got a little credibility gap there with the judge. A judge tends to believe police officers over other people. Okay? Just as a rule. If you say something and a police officer says something, guess who he's going to believe? Okay? It's going to be the police officer every time, or almost every time, unless you can show that for some reason the police officer is not credible. But other than that, he's going to give the police officer the greater weight. And also, the best kind of witness is somebody who's not a friend or a kin. In other words, unrelated to you in any way. Because friends and family tend to be biased for your side. So if you have somebody who's neither friend or kin or friend or family or anything else like that, they're a good witness. They're a better witness than somebody else. However, let's say the only witness is somebody that's on your side. In order to give them credibility, what you need to do is, let's say that that somebody was painting a fence and your car was next to the fence, and they got paint on your car, and they refused to, you know, pay for the damages to get that corrected, etc. So you brought them to small claims, and the only other person who saw that was a friend who was there talking with you at the time. Well, the way to make their testimony more credible is for them to appear to be as neutral as possible. For instance, and saying that, yeah, I saw the person, he was next to the car painting the fence. Says, but I can understand his difficulty because there was a lot of wind wind at the time. And I noticed he was having a hard time painting the fence in the wind. Okay? Now the person doesn't look like he's a one-sided person. He's also